live from the SABC's Auckland Park studios. Welcome to this week's last edition of The Watchdog. My name is Vuyo Mvoko, and on the show tonight, a new proposal to keep the president's office in check. But will it get the necessary buy-in from the governing ANC? I speak to the MP behind it. A civil society initiative to hold parliamentarians, in particular, more directly accountable, gets traction. Members of our panel for this evening are fresh from a day of deliberations on the feasibility of making this a reality as early as the 2024 national and provincial elections. The Watchdog starts now. Members of Parliament seem to prefer judges to decide whether or not President Cyril Ramaphosa should face impeachment over the Phala saga. At least a dozen of judges' names, both retired and in active service, have been nominated by various political parties to serve on the three-member independent panel expected to probe Ramaphosa. Parties were given until yesterday to submit their nominations.
In an extraordinary move, the Speaker of the National Assembly, Nosiviwe Mapisa-Nqakula, announced that she had decided to refer a proposed motion by the ATM for the removal of the President, in terms of Section 89 of the Constitution, to an independent panel of experts, as per the rules of the Assembly. This is the first time since the dawn of democracy that a sitting president's alleged conduct has been referred to such a body. The panel will have to conduct a preliminary assessment of the proposed motion, make recommendation within 30 days whether President Ramaphosa has a case to answer before Parliament.
The Speaker of the National Assembly has received a total of 17 names of candidates nominated by various political parties represented in the National Assembly to serve on the independent panel of experts to probe the Phala farm matter.
It's understood that the Speaker is in consultation with the Chief Justice before appointing any judge into the envisaged panel, which is expected to hit the ground running should all the hurdles be cleared. The Speaker is faced with an unenviable task of picking the three-member panel, judging by the names of the senior judges who have been nominated. They too will have an arduous task of either exonerating the President or making an adverse finding, which may threaten his presidency. Vuyani Green, SABC News, Parliament.
Well, Parliament may soon have an oversight committee dedicated to keeping the presidency in check, as of course is the case with ministries and departments. But of course, if MPs, in particular the governing ANC, agree to the proposal. Well, on the line, I have the man sponsoring this proposal, and that is IFP MP Narend Singh. Mr. Singh, good evening. Thanks very much for your time. Give us a background to this thought.
Well, good evening, firstly, Mr. Mvoko, and good evening to your viewers. Yes, it's now 27 or 28 years into our democracy, and although the Constitution enjoins us to have oversight over the executive, there's one member of the executive that does not have an oversight committee to oversee the expenditure within that particular vote, and that's vote one, the presidency. As the IFP, through Prince Mangosuthu Buthelezi and other parties as well, whenever we debate vote one, the presidency, we always bemoan the fact that the president himself has to answer certain questions which could well have been answered in a portfolio committee. I think your viewers are aware, and you are aware, Mr. Mvoko, that before every budget debate, we interrogate the budget of those 41 departments that we have. But unfortunately, it hasn't been the case for vote one, the presidency. We have interrogated certain ministries in the presidency, which fall under the presidency, but not the vote, the entire vote. So I've put a proposal today to the Rules Committee through the Speaker that we need to do what the Constitution enjoins us to do, apply the rules of Parliament, and put in place a committee that will interrogate Vote 1, the presidency.
From in the past, what stood in the way of this particular proposal?
Well, if I may be blunt about it, Mr. Mvoko, the ruling party. Because this is not a proposal that I've only put in today, but it's a proposal that has been going on for years. But fortunately for us, the Speaker agreed to include this item on the agenda of our Rules Committee this morning. And I referred all members of the Rules Committee to Section 55 and Section 57 of the Constitution, and then tied that in with Rule 255 of Parliament, and said that it is absolutely necessary for us to have this committee established. And I'm a bit concerned, while I accept that it will go to the subcommittee for unpacking, I do not believe that any member in that subcommittee from any of the parties could really object to something that is an imperative in our Constitution.
But what were the objections, previously? Why was the governing party not so keen on this?
Well, I think, they didn't want members of the opposition or anybody else to get close to the president. I think they misconstrue the fact that if we have a committee of oversight, we question the accounting officer of Vote 1, which is the Director General in the department, on all aspects of funding within the department, which runs into billions, all aspects of setting up of other committees, etc. And we don't expect the Honorable President in a 1-day or 2-day debate that we have on Vote 1 to be able to answer all these questions. And, we need to talk about cost-cutting measures. We need to know about travel expenditure. We need to know about staffing, etc. And that is something that you can only elicit responses from when you have an oversight committee that really delves into those matters. So I believe that the ANC need to realize that this is not calling the president there in person at every committee, but calling his Director General to account. And obviously, as we have now, the ministers do avail themselves when portfolio committees interrogate their budgets. So when it is necessary, the president, as the head of the executive, or that vote, will also have to present himself in a portfolio committee.
But if the governing party was opposed to this, or has been opposed to this all along, 28 years to be exact, what makes you think the situation is going to be different this time around?
I think there's a greater realization that accountability is the order of the day. We, as representatives of the people, have to hold the executive account, and we have to do that in a meaningful manner. And I am quite sure, as the chief whip of the IFP, that the president himself will have no objection whatsoever to this committee being established. In fact, it's going to assist the president when his budget vote is debated.
Well, so, the Q&A session, Wednesday's Q&A session, is anything to go by, looks like the more things change, the more they stay the same.
Well, we hope not. We always live in hope, but we've also got to respect this Constitution, which we hold sacrosanct. So it is a legal imperative rather than somebody's wishes not to have this committee established. And I am pretty confident that the subcommittee will work out how the committee should be established, what number of members should serve on this committee, so we can get it moving at least before the next budget Vote 1 is presented in Parliament for debate.
What happens if, once again, the governing party says no?
Well, I think, Mr. Mvoko, I'm very glad that you've asked that question, because certainly we will consider other options that are available to us.
And those being?
And I wouldn't want to disclose those options that are available, but I think you well know that we have the judiciary, we have Parliament, we have the executive, and we'll try and use one of the arms of the state to get across what we believe is a right, and not, for somebody to think whether they like it or not.
Just perhaps to end on this note, one understands, the role that your portfolio and select committees play, but that's only when they actually do what they are constitutionally mandated to do. I mean, SCOPA is one example, of a committee that actually, does do a good job. For a number of committees, the same, cannot really be said. And I was reminded of this only the day before yesterday, when the Auditor General released the report on the management of the floods in KwaZulu-Natal and the Eastern Cape, and the committee chairs actually admitted that a lot of the, they could argue any differently, but a lot of the committees don't actually do what they are supposed to do. In other words, even though they are there and they do exist, they actually don't do what is expected of them. So would you really go out of your way to fight for this one when you have dozens of them that aren't really that great?
Yeah, no, we'll definitely fight for this one. But may I also say that the other committees, do exercise oversight, maybe some more than the others. And I think this is something that also came up in the Zondo Commission report. When the report was finalized, they did point to certain omissions and commissions within the way how Parliament works. And I can assure you and your viewers that Parliament as a whole, led by the Speaker, is seized with looking at how we can strengthen our oversight role. And this is something we discussed in a training workshop about a week ago. So we are hopeful that as we move forward, there will be a fresh breeze into how committees operate. And that also importantly, that committees are given adequate resources, both financial and human resources, legal people and other people, to enable them to do the kind of work that is expected of them. When we look at parliaments abroad, we find that an ordinary member of parliament could have up to 6 people supporting that member. We are far from even having enough support for a committee. And these are things that we need to look at, and we will continue as we look at the budget of Parliament to fight for additional support for us to be able to exercise our responsibility.
Any idea how long it's going to take before a decision is taken?
Well, that question was asked earlier on. We wanted a time frame. And the response from the Speaker was that I have now directed you as the Subcommittee on Rules to look at this matter, and I will expect a response soon so that the matter can come before the Rules Committee again and then to the House for adoption. Now, unfortunately, the last Rules Committee we had was on the 13th of August last year, and the Speaker has assured us that there will be quarterly Rules Committee meetings, and we are hopeful that that will happen. So we expect the Subcommittee on Rules to consider this matter, and I will also be present at the subcommittee to consider this matter within the next quarter so that it's presented to the Rules Committee and then to the House for adoption.
Mr. Naran Singh, let me thank you very much for your time this evening.
Thank you indeed.
He is, of course, a member of Parliament from the Inkatha Freedom Party. He has made a proposal that Parliament establishes an oversight committee dedicated to the presidency, which, of course, is the case with the rest of the ministries and departments. But of course, to make that happen, this proposal would need the backing of the governing party, the African National Congress, which up until now hasn't been keen on such an idea. We'll see how, whether things are going to be different this time around. After the break, a civil society initiative to hold public representatives more directly accountable gets traction. Our panelists for that discussion are fresh from a day of deliberations on the feasibility of making this a reality as early as the 2024 national and provincial elections. The IEC has warned that if the Electoral Amendment Bill is not close to being finalized by early next year, then preparations for the 2024 poll could be compromised and impact on its integrity. The bill emanates from a June 2020 Constitutional Court judgment ruling, that is, that the Electoral Act was unconstitutional as it prevented independent candidates from contesting national and provincial elections.
The Constitutional Court had given Parliament until June of this year to amend the Act. It further granted it an extension to finalize the bill by the end of the year. However, the time granted for additional consultations this week may present a challenge due to tight timeframes. Now this means Parliament has just 3 months to conclude the Electoral Amendment Bill ahead of the 2024 national elections that are anticipated to be a watershed moment for the country.
In order to have a well-managed election, you need certainty on the electoral system at least 18 months before.
If you're going to have constituencies, it's definitely not something that there's going to be time for us as an election management body to implement for 2024.
But former chairperson of the Electoral Commission has given the current leadership this warning.
Last year you were at your best. So you ran a very big risk because of the good reputation and the real confidence, by the way, that many people in this country have. So be prepared for the worst, because there are many of us who are afraid that, we'll be dead. So the sooner we can fight now and change this problem.
Meanwhile, the Council for the Advancement of the Constitution is of the view that the bill is not fit for purpose.
It can very easily be argued that the bill that is currently before Parliament does not facilitate free and fair elections.
The Ministerial Committee on the Electoral System, which was formed by the Minister of Home Affairs, Aaron Motsoaledi, had developed 2 models for the electoral system, the Minority Report and the Majority Report. The amendment bill has taken the form adopted by a Minority Report, which makes minimal changes to the Act.
3 members of the committee went with option 1, which was basically an option to make as minimal a change as possible to the current electoral system. So to change the electoral system in as much as was required to comply with the judgment, and that alone. 4 of us advocated a more wholesale change, which was a mixed member model with single member constituencies. So basically that we adapt the local government system that we have and apply it to national and to provincial. So that you have 200 of the 400 MPs in Parliament be directly elected by constituencies in a first-past-the-post system, and 200 of the MPs be elected through a closed-list proportional representation system.
As civil society organizations debate the status of the Electoral Amendment Bill that must be passed by December, it is clear that an overhaul of the system will have implications on the 2024 national elections. Natasha Piri, SABC News, Johannesburg.
To discuss this issue further, I'm joined in studio by Dr. Michael Atkins, an independent elections analyst. And on the line, we have Lawson Naidu from the Council for the Advancement of the South African Constitution. Gentlemen, good evening to both of you. Thanks very much for your time.
Good evening.
Let me start with you, Lawson. Just from that bite, the clip, the bite that was in that package that we just played, which suggests, where you suggest that, the effort that Parliament has been engaged in up until now, all of that actually amounts to naught from where you're sitting.
Yeah, as explained in those clips, the system that government and Parliament are now processing through this draft bill before the Home Affairs Committee does not meet with the requirements that are set out in the judgment of the Constitutional Court. Because the Constitutional Court says you have to create a mechanism for individuals or independent candidates to contest national and provincial elections. And to try and use the current list system to do that simply does not work. It is fatally and fundamentally flawed. The reasonable system to accommodate individuals or independent candidates within the electoral system is through a constituency model, which is precisely the model that we have at a local government election, a local government level. And therefore, we are arguing that replicating that local government electoral system at a provincial and national level would be the simplest thing to do because voters are familiar with it. It serves the purpose of bringing elected representatives closer to the people. And the other point to make here, Buya, is that the system that is currently being proposed does not exist anywhere else in the world. It is totally unworkable and unsuitable for what we're seeking to do, which is to create an environment where independent individuals can contest national and provincial elections. What the court said was that the rights enshrined in the Constitution in Section 19 include the right to stand for election to office. But the way that this bill has been formulated actually detracts from arguably a more important right, which is the right to vote, because it undermines the integrity of the electoral system as a whole.
Michael, is it for a lack of trying on the part of the members of Parliament who have been working on this bill?
Firstly, may I say that the doctor is an exaggeration of my qualifications. I'm merely Mr. The committee has worked very hard, but they have worked on the bill that they were presented with by the minister. So if I can say, the problem lies with the original proposal put forward to the MAC committee, and there were the assumption that it worked, it would just work. But when you change a system is interconnected. When you change it, it has effects all around that system. So you change one part, it then has an effect somewhere else. So any physicist or anyone who works with system dynamics, any engineer understands you can't turn one dial and hope that nothing else is affected. So the committee has worked extremely hard on a difficult task. But the problem lies with the original arrangement.
What should have happened in your view?
Well, the problem with the system put forward is that individuals are included on the same ballot as parties. It is a proportional system. We all know that an individual and independent can get only one seat. So effectively, if a person wins many more votes than one seat, those excess votes have to be removed and the excess seats have to be redistributed. And the only way that that can happen creates a distortion in proportional representation. And one of the main effects is those excess seats primarily benefit the largest parties. So that creates a distortion which fails our constitutional requirement of proportional representation.
Lawson, the last time we had a conversation on this matter with the chairperson of the committee that is running with this in Parliament, but I also had Musa Maimane, if I recall correctly, and the political players said, well, from where they sat, it would seem, and I'm hoping that that I'm representing their view correctly, was that those who are the political parties we have, who are represented in Parliament, are not so keen on this. They're being dragged, kicking and screaming for the simple reason that they want to keep those who are outside.
And that's a fundamental problem with this process. It's being determined by political parties who have a vested interest in the electoral system that we use. They are inherently conflicted and have not given due regard to the submissions that have been made by members of the public and civil society organizations. And of course, the current model suits political parties very well. It suits the bigger parties because they're able to retain ultimate control over their MPs. If they stray out of line, they run the risk of losing their seats. For the smaller parties, it means that this is the best opportunity for them to have representation in Parliament, because any kind of constituency system would adversely affect the smaller parties. So there's a convergence of interests, albeit for different reasons amongst political parties. And that's why we're arguing that the people of South Africa need to have a bigger say in the design of the electoral system, because ultimately the electoral system needs to be about voters and not about political parties. The Indaba that we held today in Johannesburg demonstrated the kind of vibrant debate and discussion about the electoral system, which was totally absent from the public hearings that the Portfolio Committee held in March of this year. And if they had conducted the hearings in the manner in which we conducted the Indaba today, they would have seen the overwhelming views of representatives of civil society organizations and interested individuals who are arguing very, very strongly for a constituency model. But having said all of that, we have a potential crisis on our hands, because this legislation, as the IEC has demonstrated, needs to be passed as soon as possible in order for the IEC to be able to prepare and plan properly for the 2024 elections. So a compromise is going to have to be found to enable us to conduct lawful elections in 2024, whilst keeping the issue of meaningful electoral reform on the table. And I think that there can be no greater argument in favor of fundamental reform than what has come out of the Zondo reports, where he speaks constantly of Parliament's failure to do anything. Even when they were presented with evidence of state capture, they simply turned a blind eye, and there were no consequences for any of them.
In fact, I want us to explore that further, especially in light of, on the back of what the Chief Electoral Officer had to say, around this. But before we do that, Michael, I just want your thoughts on whether you share the view or sentiment of the people who argue that the main reason for this apparent reluctance on the part of the political parties represented in Parliament to do the right thing is because they just want to keep everyone else out. Your thoughts?
Look, as an analyst, I wouldn't speak to people's motives. If I can make any inference, it's that people often don't question what is put before them. So you had some experts on that advisory committee who put forward this proposal. Although it isn't in use anywhere in the world, nobody sat down to say, well, let's pick this apart. Does it work? What are the consequences of the system? What are the numerical outcomes? And essentially, there was a need to model those outcomes and see whether it meets the constitutional tests of fairness, of fair elections, of proportionality. So I would look at the lack of grasping the nettle of this as simply not questioning the fundamentals. I won't speak to political motives or anything like that. The interest is, do we have a system that works? Is it fair? Is it constitutional?
grasping the nettle, Michael says, Lawson, and I don't want to undermine or second guess or belittle or, those MPs, but do they fully appreciate, the nature, extent, gravity, of what has to be done, to give them the benefit of a doubt that perhaps they're not doing this deliberately. It's not for lack of trying. Perhaps they're just limited by what they know or have been exposed to.
Vuyo, that's a really important question, and it's a question that was addressed in his closing speech at the Indaba today by Vali Musa, who was the chair of the Ministerial Advisory Committee and part of the majority view of that Ministerial Advisory Committee. And he told us in his closing remarks that he has spoken to a number of people within the ANC and within other political parties to say, do you realize the implications of this bill? And he used an example that, if you need, for example, 50,000 votes to win a seat, and an independent candidate gets 500,000 votes, 450,000 of those votes are then wasted, and as Michael has explained, gets reallocated to the benefit of political parties. And when those things are explained to people, they haven't realized those implications of what's contained in this bill. So there's been a serious lack of understanding, even by our legislators, of what they are actually proposing and may well pass, which is going to be a fundamentally flawed bill, as I've said. So, there's not been the level of debate. There hasn't been proper engagement, for example, with the majority view of the Ministerial Advisory Committee, which echoes recommendations that have been made to Parliament by, for example, in the reports of the Zondo Commission, in the report of Kgalema Motlante's high-level panel in 2017, by the Independent Panel Assessment of Parliament in 2009. And I even drew attention this morning to the fact that in his last speech to Parliament in 1999, President Nelson Mandela also urged Parliament to reconsider an electoral model that brings the voters closer to their representatives. Parliament has ignored all of these issues and continues to do so to the detriment of our democracy. And we're seeing, as a result of that, decreasing levels of trust in political processes and decreasing levels of voter participation in elections. And that's something that the electoral reform process can begin to address, so that people begin to have confidence in the process, that the people that they elect are in fact accountable.
Outside of the other possibilities of posed, Michael, how much of the problem may also or may well have to do perhaps with the imperfections of the current system?
Look, I don't see imperfections of the current system having a bearing on the conundrum we find ourselves in at the moment. The current system works well. Obviously, the court found that it is limited in the broader picture of representativity in South Africa and fairness and the rights that we enjoy. But as a system, the current system works extremely well. But the change of introducing individuals has been bigger than anybody anticipated. People view those seat allocation methods as a black box. They don't interrogate them, and there are some unintended and unanticipated consequence of having individuals who can only get the one seat thrown into that spreadsheet. So you get some very funny numbers coming out and very funny patterns. And that is the problem, that at the beginning, nobody sat down and unpacked those models in time.
Speaking of time, Lawson, the Chief Electoral Officer, says they need, at the very least, 18 months before an election to know what they are going to have to work with. And as things stand, all things considered, all sentiments expressed, considered, it doesn't look like that is going to happen. What were some of the suggestions there? Do we work? Is it possible to still work towards the 2024 national and provincial election and have something that as close as possible resembles the ideal? Or do you say sacrifice 2024, perhaps work on something that will really work, that will be proper, but certainly look beyond 2024?
No, you're absolutely correct. We have to look beyond 2024. But we also have to ensure that we are able to hold a constitutionally compliant election in 2024. And given the time frame constraints that the IEC have spelled out very, very clearly for all of us, we need to pass this legislation in some form by the end of this year to enable the IEC to conduct free and fair elections in 2024. That may well mean that we're going to have to live with hopefully an improved version of the current bill that is currently before Parliament, incorporating individuals or independents within the current list system, but with a proviso, and a very clear proviso that needs to be included in the legislation, that this electoral system will be an interim one, will only be applicable for the 2024 election, but that Parliament continues even now, ahead of the 24 elections, to formulate a new electoral model that really meets the needs of South Africa at this time, to enhance accountability and to use a system that, as I said earlier, the voters are already familiar with, which is a version of the local government election system model. So that's really what faces us now. And it's up to the committee to incorporate the changes to the current bill, to iron out some of the rough edges that Michael has explained in terms of the mathematical inconsistencies that emanate from this bill, and to try and create a bill that is constitutionally compliant, although not meeting all of the needs for South Africa at this time, but that we have a commitment from Parliament that once the 24 elections going to take place on that basis, the discussions, meaningful discussions, continue so that we can collectively, as South Africans, agree on the right electoral model for the future. Because this is not about one election in 2024. It is about the future of our democracy in South Africa. And this is a really important conversation that all South Africans need to engage in.
Michael, your thoughts on the feasibility of a constitutionally compliant, bill, well, act, it should be by the time it gets implemented before 2024?
Right. Certain of the major problems were addressed during the committee deliberation period. There are a number of faults in the current bill. Some of those can be corrected and some of them can be improved. I take a different view from an analytical point of view, looking and modeling the outcomes. It's my considered view at the moment, and I'm happy to be corrected, but it's my considered view that it will prove impossible to bring this bill to the point of compliance, because we don't only look at the composition of Parliament, we have to look from the perspective of the voter. What is the effect of my vote? So what would people feel if they vote for an independent candidate and 1/4 of that ballot counts towards the largest party? But that's an unavoidable consequence. So I have serious doubts that even tweaking the numbers, we can push it and improve it and get closer. In my view, we can't actually cross that bridge.
There's this phrase that what is being done or attempted here doesn't exist anywhere else in the world. And that's what's worrisome, because we have no model,
Yes.
Let's trial and error, you know. So it's not a recipe for disaster, you know, on the way to 2024 then?
The committee has worked very hard. They really have put in a really good shift on this. I have to call it as I see it. From my perspective, from looking at those spreadsheets, from trying out the various systems and the changes as they have been implemented by the committee, I have to call it, we can't cross that bridge. The bridge does not reach the other side. So yes, I'm saying we can't reach a constitutional version of this bill in time for 2024.
Scary. Michael Atkins, Lois Naidu, thanks to both of you for coming through this evening.
Thank you.
Well, 2 weeks after the murder of abahlali basemjondolo activist Lindokuhle Mnguni, grassroots organization Forward to the Assembly of the Unemployed is calling for the Minister of Justice, Ronald Lamola, and the Minister of Police, Bheki Cele, to urgently address the killings of abahlali basemjondolo. We'll look at that issue in a moment. Parliament says it's reviewing its security measures after a fire that ravaged some buildings in the precinct earlier this year. Officials today briefed the Joint Standing Committee on Financial Management of Parliament on its performance in the first quarter. It also emerged that at least one unnamed political party has not submitted its audited financial statements. It therefore has not received its regular financial allocation or won't receive it until it comes clean.
The fire damaged both the National and the Old Assembly buildings. The cost of rebuilding the damaged structures is estimated at more than 2 billion rand. This incident has forced Parliament to tighten security measures.
Yes, we are reviewing those security measures, honorable members, but it also requires of us to strike the right balance between deepening vulnerability of the institution given where we come from, the unfortunate incidences of attack, the numerous attempts that police and our parliamentary security staff keep on experiencing.
In another development, not all the 14 political parties represented in Parliament have submitted their audited financial statements. They are required to submit audited statements before receiving their allowance.
The political parties that have not submitted the financial statements, could we have an indication of who they are? Of course, it's going to prejudice them because they would not receive allocations.
But George did not disclose the name of the party.
I'm advised, Chairperson, that this has not ordinarily been indicated that Party A is the one that is outstanding. So I can take guidance if we need to mention the name.
George says he hopes that they will receive the required financial statement before the end of the year. Lula Mamatya, SABC News, Parliament.
Well, of course, we were trying to, as you would have guessed, buy time there because we had lost our guest. We seem to have him back 2 weeks after the murder of abahlali basemjondolo activist Lindokuhle Mnguni. A grassroots organization Forward to the Assembly of the Unemployed is calling for the Minister of Justice, Ronald Lamola, and the Minister of Police, Bheki Cele, to urgently address the killings of abahlali basemjondolo leaders. It's alleged that Mnguni was a witness to the murder of another leader, Ayanda Ngila, who was killed in March. In the last 6 months, 4 leaders of abahlali basemjondolo have been killed. The total number of killings over the last 10 years sits at 24. Joining us now is leader Sibusiso Zikode, who is the president of abahlali basemjondolo. In the last 6 months, has the police ministry or the Department of Justice actually engaged your organization?
Good Good evening to you, Vuyo. No, unfortunately, the minister and all law enforcement agencies have refused to investigate. They have refused to engage with us. The impunity continues. It is unfortunate that none of them really doing anything following the ongoing slaughter of the leaders of Abahlali.
When you say they have refused, what do they say when you talk to them, when you approach them, when you go and...
Well, I'm saying they are refusing because I have personally spoken to the Minister of Police as early as from October last year, because we've seen this coming and the minister hasn't really done anything. He will make a promise. For instance, the minister will say he will speak to the Provincial Commissioner of Police in KwaZulu-Natal, or sometimes he will say, Sbu, I'm coming to KZN. And that is why we are not afraid to say that the blood and the soul of Lindokuhle Mnguni, Ayanda Ngila, Nokuthula Mabaso, as well as Manqele, needs to be asked in the hands of the minister. So the minister himself has the blood of the 4 activists that have been killed because he has been informed, made aware of the volatility of the situation in Katomena, because his police are also not doing anything. And we suspect that the police have been given an order from above not to act, not to protect the lives of Abahlali. So the police minister is responsible for the murder of the 4 activists that have been murdered this year.
Is the motive very clear? I mean, who would want to kill activists of Abahlali Basamjondro?
Well, we are clear. There is a housing scandal in the greater Katomena. The RDP houses are being sold in the broad daylight, and those who are exposing the sale of the housing, but also those who want to use the land in which the Ekanana occupation is, they actually want to build flats, they want to build property so that they can make money. So they feel that the land on which the settlement is occupying is too good, that there are investors that are behind wanting to make sure that Abahlali members are being evicted so that they can make use of the land to make profit and sell the property.
So let's leave it there for tonight because of course, we've run out of time because of those delays in establishing and re-establishing your line. But thank you very much for at least being able to put this on the agenda of South Africans. This thing has been continuing for years now. Abahlali Basamjondolo leaders being killed, but no investigations, no clarity as to who's responsible and why they are doing this. But that's our show for tonight and for this week. Do join us again on Monday. Have a good night and a great weekend.